Today's episode takes us to Harris County Criminal Court in Houston, Texas, where Judge David Fleischer has built a reputation for scrutinizing the state's evidence and ensuring the government meets its constitutional obligations. Across a series of recent hearings, Judge Fleischer presided over probable cause determinations for 3 different defendants, and then returned to one of those defendants for a separate proceeding, raising its own distinct legal question.
Houston, Texas, a courtroom where the judge doesn't just make decisions. He challenges the system itself. In today's case, what starts as a simple disturbance call quickly turns into something much bigger. Michael Jones, one encounter, but what happens next completely flips the entire case.
And on February 19th, attorney Lisa Tichy appeared in front of Judge Fleischer to argue probable cause on Mr. Jones's behalf.
Hi, good morning, Judge. My client is Michael Jones, and he's in custody, and he's asked me to argue probable cause for him, and so I
Sure,
shall.
of course. You ready?
Yes, Judge. Does he need to be brought out, or do you? I don't know your process.
Mr. Jones, please. Yeah. It's only fair because it's his case, so we might as well bring it
No,
up.
he asked me to do this, and so I told him I would.
Yeah, this is Michael Jones.
Yes, Michael Jones.
He must be unhappy, huh?
Asked him to breathe.
Or hungry.
Asked him to breathe.
Good morning. How are you?
Hey, buddy.
If you're banging on the door, you got to be careful because you break something, you're gonna catch another charge. So be careful banging on those windows because they break very easily. All right. So you were Michael Jones. Mr. Jones, we're talking about you, so that's why I wanted to bring you out. It's only fair that you get to hear what's going on with your case. Your lawyer wants to challenge probable cause in this case. You're charged with interference with the duties of a public servant. You are facing up to 6 months in jail and or a $2,000 fine. That's what you're charged with. I don't know. So I'm going to have them read, and we're going to do probable cause to see whether we're going to go forward or not. Okay? Okay. What happened?
On January 10, 2025, the officers in official uniforms and riding in a marked patrol vehicle were dispatched to a disturbance at a residence in Harris County, Texas.
According to police, Michael Jones was standing outside a residence and was asked to leave, but refused. Officers arrive, and that's when things suddenly escalate. Jones begins to walk away, but police move in to stop him, and this is where the real conflict begins.
Hands behind his back, and the defendant pulled his hand away. The defendant refused to comply with verbal commands, and the defendant held his arms to his chest as the officer attempted to detain him. The defendant continued to refuse additional commands to stop resisting and put hands behind his back. He yelled at the officer in an aggressive tone and shouted out loud, "Don't let them take me." The officer performed a leg sweep and continued to struggle handcuffing the defendant due to him pulling away. The officer began to roll around while on the ground and reached the officer's hands to prevent him from being placed in handcuffs. The officer continued to give commands, and the defendant continued to refuse.
I get it. But what's he doing? I mean, he's walking away. That's what they wanted. Right?
So,
No.
Just losing?
Your Honor, in this case, to read the full dim, it was the disturbance call, and they said they observed him standing outside the above location being told to leave, and they observed him verbally refuse, and then...
Right, but then cops get up there.
And then they observed him begin to walk away, and it says they approached Jones and observed he was intoxicated in a public place based on his slurred speech, pupil size, and...
Didn't say that.
That was in the complete dims, Your Honor. And then it
Did you know about that?
And
Yes,
aggressive
Judge.
behavior.
But
Okay,
I
go
have my
ahead.
argument prepared. Judge, my argument is exactly what you started to say. There's some sort of disturbance. Somebody's asking him to leave. They're yelling and screaming at each other. Police coming up and saying, "Hey, I'm the police." You can walk away from that all day long. My client did walk away from that. My client's loud and emotional, as you can tell here today. You're allowed to walk away emotional, yelling, screaming, even using profanity in this state if you want to. Then the cops come up to him and suddenly there's some kind of unfounded allegation of intoxication. There's absolutely no facts other than that statement. "I smell marijuana. You look intoxicated," because it looks like he walked away and the cops didn't want him to walk away. And so now they need a reason to arrest him. My argument is based on if he's charged with interference with a public servant, that doesn't come until later. He has to be lawfully arrested and lawfully detained or lawfully with the police before that even occurs. Walking away when a resident tells you to leave and all you've got...
The defense immediately raises a powerful point. If he was already leaving, why were officers trying to stop him? Is simply saying, "We are the police," enough to detain someone? This moment sparks a legal debate that could decide everything.
intoxicated. So does it go into a potential public intox investigation?
If it does, they need to announce that. You can't just walk up to me and say, I'm the police, stop. We don't live in that kind of society. I'm the police, I need to investigate you, so therefore stop all day long. I'm the police, we're investigating, I need you to step aside, sir, so I can investigate this matter all day long. But hey,
So-
I'm the popo.
The reasonable suspicion we have is they begin to investigate what?
So
A criminal trespass.
they're called, yes, a disturbance, and they saw him yelling, being aggressive, and then as he walked away, that's when they saw
So
signs.
the trespass investigation ceases because he's leaving. Yes or no?
It's not specified to be a trespass, Your Honor. It's specified just to be a disturbance.
That's what it is. Okay, but it's a trespass that they're investigating a trespass, right? I mean, for all intents and purposes, isn't that what it is? The investigation begins as a trespass investigation because he's there. Homeowners asked him to leave. He's refused to leave. So cops come and he begins to leave. So at that point, all should have ceased. But the cops go up to try to.
Well, in this case, Your Honor, it would be that, yes, he attempted to leave, but once the officers arrived, so they would still need to investigate to determine if the trespass even occurred, to determine,
He's leaving.
He's walking.
He's leaving. Right? It's like, here, let me come and mess with you more.
That would only,
Right? So it's like adding fuel to a fire.
but they would still have grounds to investigate, and furthermore, with the further signs of possible public intoxication, it would give them further grounds to investigate.
That's because they're going up to him to mess with him.
Well, they're going up to investigate what they saw him refusing to leave, and he
leaves.
He only left once they arrived. So with maybe potential fear of apprehension, that's when he decided to leave, which it wouldn't undercut their ability to investigate what they had observed happen in front of them regarding that public or that disturbance that they were called about. They still need to figure out what happened there and if there was a trespass to begin with.
Judge, you can't flee a trespass. The way you comply is by fleeing.
Well, we don't know it was a trespass, it was a disturbance. We don't always specify the disturbance.
I'm going to find no probable cause.
You understand?
Mr. Jones, be careful, man. We have enough drama in this life, don't we? You don't like to wear orange, do you? Be careful where you go. Be careful what you do. Everyone's always out to get you, man. Don't let them. All right, man. Good luck.
Thank you.
Unless you.
Thank you. Hear what happened?
The state charged Mr. Jones with pulling his hands away from officers who were attempting to place him in handcuffs, thereby interfering with an officer.
The judge now sees the situation clearly. If there was no trespass, then the detention was unlawful. And if the detention was unlawful, then resisting it isn't a crime. With that single line of reasoning, the entire case collapses.
Judge Fleischer agreed that once Mr. Jones started to leave, the basis for any trespass investigation had evaporated. Under Section 30.05 of the Texas Penal Code, criminal trespass requires that a person remain on property after receiving notice to depart. If Mr. Jones was in the process of leaving when officers arrived, Judge Fleischer reasoned that there was no trespass occurring and no reasonable articulable suspicion of one, which meant officers had no lawful basis to detain Mr. Jones. Under Section 38.15 of the Texas Penal Code, interference with public duties requires that the defendant obstruct an officer who is performing a duty or exercising authority imposed or granted by law. If the detention itself lacked legal justification, then Mr. Jones pulling his hands away or taking an action to interfere with an unlawful detention could not form the basis of a criminal charge. Accordingly, Judge Fleischer found no probable cause, and the case was dismissed. On March 27, 2025, defendant Brandon Deshawn was charged with reckless driving. A probable cause hearing was scheduled in front of Judge Fleischer on April 4th, 2025.
You are Mr. Deshawn. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Your Honor, on March 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle make an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. The defendant then traveled 88 miles per hour in a 50-mile-an-hour zone and made an unsafe lane change while speeding.
That's it?
Yes, Your Honor. The information, the charging instrument alleges that the reckless driving is based on a willful and wanton disregard for the safety of persons by driving more than 35 miles over the posted speed limit.
I'm going to do this. I'm going to take more time with yours. Just take a seat for me in the jury box so I don't forget about you, Mr. Sean. I'm not ready to make a ruling on this yet. Grab your stuff. Just hang tight with me. Can you point him somewhere real quick?
Yes.
Yeah.
Reckless driving, Judge Reed. Do you want him up?
No.
But it doesn't end there. The next case involves reckless driving. The charges sound serious, but one key question from the judge starts to expose cracks in the story.
27, 2025 in Harris County, Texas, officer observed the vehicle made an improper turn, nearly causing an accident with the vehicle turning next to him by turning into the wrong lane. Defendant then traveled at 80 miles per hour in a 50 mile per hour zone and made an unsafe lane change while speeding. Also, I watched the video for this one, so I can answer questions on what actually was observed or what I observed on video.
So let's break it.
Complaint, it basically alleges unsafe lane change. Does it really?
Is that the basis for the reckless driving, the unsafe lane change?
So the way that the charging instrument reads is essentially word for word is a recklessly drive vehicle was in willful and wanton disregard for safety of persons and property by driving more than 35 miles per hour over the posted speed limit, making unsafe lane changes, causing other drivers to have to take evasive action and avoid collision with the defendant's vehicle.
Is that what you saw?
As I did not observe any vehicles having to take evasive action. What I observed specifically was the defendant coming out of the parking lot on Theater Road. He does cut across 3 lanes to go to the far lane, but I didn't see any vehicles having to take evasive action, slam the brakes on. In terms of speeding, I'm not sure if he was speeding or not, but it did look consistent with the flow of traffic with the exception of passing other vehicles.
I'm going to admonish you.
I think that's fair, Your Honor.
Come on. Who is it again?
Brennan?
Mr. Deshawn, do you watch the news?
Yes, sir.
Do you really? Do you really watch the news? Every single day in our county, someone dies because of a boneheaded move that's made in a car. Every single day. Not just one, multiple lives are taken on our streets just because people drive in such a manner that they end up killing someone. Yours is not the worst, and I'm going to find no probable cause. But be safe. You know, we're not asking for much. Don't drive unless you have a license. Don't drive unless you have car insurance. I tell you, I get so many emails every week because people...
As the judge digs deeper, the evidence begins to fall apart. No clear danger, no vehicles forced to react. And suddenly, the prosecution's claims don't match reality.
They don't know where to go to, where to turn because someone filed a lawsuit against them. If someone does that and you get a judgment against you, you're hosed. Get car insurance. And when you drive, do it in a manner that you're not going to injure or kill someone. We're not asking for much. All right?
We had a conversation about that already, Judge.
Be safe. It's not much. You know, if you got to get somewhere in a hurry, leave earlier. All right? All right. I'm going to find no probable cause in your case. All right? Take care, man. Be safe. If I see you back, it's not going to go. All right. Please.
Thank you, Your Honor.
Thanks, Alex.
Mr. Deshawn was initially accused of driving more than 35 miles per hour over the posted speed limit while making unsafe lane changes, causing other drivers to take evasive action to avoid a collision. However, when Judge Fleischer pressed the prosecutor on what the footage actually showed, the prosecutor acknowledged that Mr. Deshawn cut across 3 lanes, but stated that he did not observe any other vehicles taking evasive action or slamming their brakes. As for the speeding allegation, the prosecutor conceded that Mr. Deshawn's speed appeared consistent with the flow of traffic, with the exception of passing other vehicles. Under Section 545.401 of the Texas Transportation Code, reckless driving requires a showing that the defendant drove in willful and wanton disregard for the safety of persons or property. That standard demands more than aggressive or careless driving. It requires conduct rising to the level of a conscious indifference to the risk of harm, with the prosecutor's own account of the footage failing to support the 2 core factual allegations in the charging instrument. Judge Fleischer found that the evidence did not support the charge, finding no probable cause, and the case was dismissed. The next hearing took place on December 4th, 2024, involving defendant Genesis McCollum, who had been charged with making a terroristic threat to a family or household member on November 15th, 2024. At the time that the charge was filed, Mr. McCollum was already out on bond.
Now comes the third case, and this one appears far more serious. Terroristic threats, messages, and alleged threats involving a weapon. But one simple question changes everything.
issue of probable cause for the terroristic threat charge.
Judge, I'd like to challenge PC on this new charge.
Okay. Have you heard it yet?
I mean, I've read it.
Okay. That's what I wanted to know, whether you've read it or not. Okay. All right, Mr. McCollum, good morning, sir. Number one, don't email me. That's not a good thing, man. Really, because I'm supposed to be neutral, detached. So I don't know what happens until if it goes to trial. So just, it's okay. But just from now on, all right. So you now stand charged. You picked up a terroristic threat of a family or a household member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. I don't know what happened in this case. I'm just now seeing it for the first time. All I know is that you're on bond for this case, for another case, and now you picked up a new one. So let's go forward and.
Officers were dispatched to a residence in Harris County, Texas. Complaining witness showed officers text messages ranging from May 2024 to November 2024, where the defendant sent her photos of guns and threatened to shoot the complaining witness and their child. Defendant also stated he would shoot up her house and hoped that he would hit her and the child.
When is the statement that he was going to shoot up the house? Was that from May and that he's just investigating this? Because that's not a terroristic threat. But if it was an active thing where he was...
Well, it looks like the offense. So per the offense report, the actual offense took place on November 8th.
Okay.
But I believe that she showed them old text messages.
Okay, so when was that statement that I'm going to shoot up the house and yada, yada? Sure, take your time.
And Judge, while they're looking, it's not alleged when the statement was. Not only that, it's not reported until 3 days later. In the reviewing the text messages that have been submitted, there's not a single text message that has that specific threat in it.
Well, I don't know. I mean, it's the state's burden to show, I don't know, but terroristic threat has to be an immediate fear of harm.
So I don't see an actual date in the offense report. I personally have not reviewed the text messages in this case, Judge. I don't see a date of the actual threat.
That's not a good thing. I mean, who knows when that statement was made? Could have been made 2 years ago. Could have been made yesterday. Yeah, I agree with you, man. I mean, if you don't have anything else, then that's it. Okay, I'm going to find no probable cause. Mr. McCollum, we're not asking much, man. We want our streets to be safe. I'm going to do everything in my power to protect the streets, right? If I find that you're a problem, if they call back and it continues to happen, it's not going to go well.
The judge asks for something basic: timing, proof, details. But the prosecution can't provide clear answers. And without a timeline, the entire allegation starts to fall apart.
First in you, then don't have a relationship with this person. There's a gajillion and one fish in the sea. It's not worth it to have someone rap you so bad that you make and say things that make you go to jail. It's not worth it. Do you understand? Now, don't have contact with this person because it's just not going to end well. All right? All right. So I'm going to continue bond. I'm not going to revoke your bond on this case now because I'm finding no probable cause, but just behave. It's not hard. Be nice. All right. Okay.
Judge.
For sure.
The state claimed that Mr. McCollum sent the complainant text messages containing photos of guns and threats to shoot her and her child, as well as a threat to shoot up her house. Under Section 22.07 of the Texas Penal Code, a terroristic threat requires that the defendant threaten to commit an offense involving violence with the intent to place a person in fear of imminent serious bodily injury. When Judge Fleischer pressed the prosecutor on the timing of the threat to shoot up the complainant's house, the prosecutor could not identify a date for that statement in the offense report. Defense counsel further noted that none of the submitted text messages actually contained that specific threat, and the prosecutor acknowledged they had not personally reviewed them. Now, the absence of a date created two distinct problems. First, without knowing when the threat was made, there was no way to establish that the complainant was placed in fear of imminent harm, as the statute requires. Second, Judge Fleischer noted that the threat could have been made 2 years prior, which would place it outside the 2 2-year statute of limitations for misdemeanor offenses under Section 12.02 of the Texas Code of Criminal Procedure, with the state unable to establish when the threat was made or produce the text messages containing it. Judge Fleischer found no probable cause, and the case was dismissed. On December 17th, 2024, just 3 days after Judge Fleischer's no probable cause finding on the terroristic threat charge against Mr. McCollum, Harris County Pretrial Services filed a bond condition violation report in his failure to identify case. Pretrial Services reported that Mr. McCollum's GPS monitoring device.
Even after the case is dismissed, the problems aren't over. Now it's about a bond violation. A GPS monitor going offline repeatedly, and the judge is no longer patient.
To address the violation.
I'm not happy with you. You have a monitor on your ankle. It's been dead. Is it still dead now?
I keep my charger with me. I keep it with me wherever I go. But my ankle monitor is messed up. They said it's malfunctioning. So sometimes.
Felicia, tell me what's going on with Mr. McCollum now.
I believe on the 2nd, we lost service until the 5th. And then it came back on. And then on the 8th, his last court date, it went off again for about 6 hours. I reached out to get the specific times, but I haven't heard back yet on that. But it was off for a confirmed 6 hours. And we have received signals since then back.
Yeah.
And we send messages out to tell them to report 49 to have the device inspected as well. And if they have any issues with that, they're instructed very thoroughly to let us know.
Yeah, I keep my charger with me though. But I think it's something wrong with my thing because the thing got off and gets wet when I get in the shower.
You keep your charger on you, but you don't use the charger because it has gone dead over and over. And I don't care if you come here with a baby to try to save your ass from going into custody.
I'm not trying to save him. I'm the only one that could have watched him right now.
What's going to happen if you go to jail? These are things that you think about when you're in the free world and when you have bond conditions. Because when you break the bond conditions, what happens to you?
I did call them and tell them that I think it's a malfunction with my thing. They said they could see my signals, and you
repeatedly have the device that goes out. I'm going to do this. I'm going to do that. I'm going to call this people. But you are, though. The device has gone dead. 3 days over there, now 6 hours over here. What am I supposed to do?
I was unaware of it being dead. I put it on the charger.
She's telling me they reached out to you.
Oh, they do. Every time they call me, I put it on the charger. They call me. They do call me and I put it on the charger.
Why do they have to call you to even tell you to put it on the charger, Mr. McCollum?
Sometimes I'm at school. A lot of times a day I can't charge it at school. My charger is not close to my barber station. So
why can't you charge it at night when you're at home with the baby?
I do. Sometimes it acts as if it's charging, but it's not charging. So it's not that I'm not trying not to charge. I do try to charge it every day.
Judge, I would ask if the court would instruct him to go by 49 Sanders Sound today, just for them to check the device, and if there is something wrong, for them to put it in.
I'm putting him in jail. I don't know what you're going to do with this kid, man.
I haven't done anything wrong, sir. I promise.
But you have done something wrong. You've repeatedly done something wrong.
But my ankle monitor, I didn't know it was dead. I promise you, I go to school every day.
The defendant gives excuses, device issues, charging problems. But the judge isn't convinced, because the data tells a completely different story. And now, the tension reaches its peak.
And then I have multiple dates of text messages informing the client to charge the battery.
And they call me and I answer the phone and I charge it. I charge it every time they call me. I'm not making no excuse. This is what I do. I go to school every day.
The reality is you tell me something, but the machine tells me something different, Mr. McCollum. That's the reality.
Ask if we could get, can we get it inspected or get it checked out, please? Because I know it's not.
That is what you're supposed to do at the first instance that there is a problem.
I did call them, and it's on record.
You calling has nothing. It doesn't do anything. You have to actually go down to the place and have it serviced if it's malfunctioning. But you don't.
No malfunctions with it, sir. I promise. I called them. They told me there was no malfunctions because it was going off at first when I was at school one time. I said, "What's wrong with it?" I've never been on ankle monitor before, so I said, "What's wrong with it?" I called them. They said, do you have service to outlet? I said no, but I went to a place next door to my school and I tried to charge and they said they still not getting signal from me. They still weren't getting signal. So if we can get it changed or get it looked at least,
Judge, I would ask if he could get a new device, if we could reset this a week, and
Here's what we're going to do. I'm now sending you for a drug and alcohol test. I want to know what, if anything, is in your system.
Sir.
Do you understand?
Sir.
You were to come back tomorrow. Don't come with a baby. Do you understand me?
Sir.
Don't come back here with the baby.
Sir.
Because if you're here and I put you in custody for one reason or the other, I will call CPS. Do you understand?
Sir.
But here, whoever you are, I don't care who you are, we will hold you accountable. And if you continue to piss on my leg and tell me it's raining, there will be issues. Do you understand? I will not entertain you telling me I got to do this, I got to do that, and I malfunction this. They reach out to you ad nauseum to tell you that there are issues, and you coming here and telling me, well, I don't know about this, I don't know, it's disingenuous.
Nice, we get it. Ankle monitor looked at.
Just go to 49 San Jacinto.
Where is that?
49 San Jacinto.
First thing is first, I'm sending you for a drug and alcohol test. And then I will give you the benefit of the doubt right after. Have you go to this place to see if there actually is something wrong. You will be back here tomorrow. Understand? Okay, honey.
Judge, they will, do you have someone else to watch the baby because they don't have a child?
Do you have someone here with you today?
No, sir. But I'll just wait outside the address until I can get somebody to come.
Okay. Do that.
Yes, Judge.
All right. All right, Judge. See you, Mr. McCollum. We'll see you tomorrow.
Mr. McCollum was accused of repeatedly allowing his GPS monitoring device to go offline in violation of his bond conditions, which required him to comply with GPS monitoring. Under Article 17.40 of the...
In the end, these cases reveal something powerful. The court doesn't blindly accept claims. It demands proof. And when the system fails, it takes a strong judge to restore balance.
Are violated. Mr. McCollum attributed the dead device to malfunctions and difficulty charging it at school. However, pretrial services reported that they had sent repeated text messages and siren alerts instructing Mr. McCollum to charge the device. Judge Fleischer was skeptical, but rather than immediately revoking bond, he ordered Mr. McCollum to submit to a drug and alcohol test, and then directed him to report to pretrial services to have the device inspected, and then return the next day for a follow-up. Court records show that the failure to identify case was dismissed 2 days later on December 20th, 2024, with the state indicating that it intended to use the charge as punishment evidence in another proceeding rather than pursue an independent prosecution. The cases examined in this episode illustrate the function that the judiciary serves in the criminal justice system. In each of the probable cause hearings, Judge Fleischer scrutinized whether the facts presented by the state actually supported the elements of the charged offense, whether a defendant who was already leaving a property could be lawfully detained for trespass, whether text messages of undetermined age could establish the imminent fear required for a terroristic threat, and whether driving that appeared consistent with the flow of traffic truly amounted to reckless disregard for the safety of others. In several instances, the state's own account of the evidence failed to satisfy the statutory requirements of the charged offense, and the charges were dismissed at the earliest stage of the process. On the other hand, the bond condition violation hearing that we reviewed showed that Judge Fleischer was just as willing to hold a defendant accountable when the facts supported it, declining to accept explanations that the evidence contradicted, and making clear that leniency has limits. Taken together, these proceedings reflect what principled judicial oversight actually looks like: a judge who follows the facts and applies the law even-handedly, neither reflexively deferring to the state nor extending unwarranted benefit of the doubt to the defense.